Here I am delivering the lecture on interpretation of Section 6 of the Hindu Succession Act 1956. This lecture is on the background of judgment of the Honorable Supreme Court in the case of Vinita Sharma versus Rakesh Sharma and others. 3-justice bench, larger bench of Honorable Supreme Court has delivered this judgment on the 11th August 2020. That on the background of said judgment, as a student of law, there is a necessity to revise the study on the subject. Hence, I am delivering this lecture. The question concerning the proper interpretation of Section 6 of Hindu Succession Act as amended by the Amendment Act of 2005 has been referred to the Supreme Court on the background of conflicting verdicts. On the background of conflicting verdicts which were rendered in two division bench judgments of the Supreme Court in the case of Prakash and others versus Phaloti and others, and another case Dhanamma and another versus Amar and others. In case of Prakash versus Phaloti, which is reported in AIR 2016 Supreme Court 769, the facts of the case was that the father Coparcenary died in the year 1988. His daughters filed suit for partition in 1992. That suit was dismissed in the year 2007. Nevertheless, entitlement was given to the daughters to a share on a notional partition under the proviso clause of old Section 6 in the share of Coparcenary father. Then matter went in appeal to the High Court. However, the High Court applied the amended provisions of new Section 6 to the pending proceeding and treated daughters equally with sons. As such, the matter travelled to the Supreme Court. The division bench of the Supreme Court held in this matter that the provisions of amended new Section 6 are not retrospective. Accordingly, in this case of Prakash versus Phaloti, the Supreme Court held that the rights under the amendment are applicable to the living daughters of a living co-partners as on 9 September 2005, irrespective of when such daughters are born. There is another decision which was rendered by the division bench in the case of Dhanamma versus Anwar, which is reported in All India Reporter 2018 Supreme Court 721. The facts of this case was One, Guru Lingappa Savadi, who was a propositus of the Hindu joint family and was the father of living daughter Coparcenary, died in 2001. That is before the Amendment Act of 2005 came into force. Suit was partition was filed in the year 2002. However, during the pendency of this suit, Section 6 of the Act was amended, as the decree was passed by the trial court only in the year 2007. In this Dhanamma case, the Supreme Court held that the amended provisions of Section 6 confer full rights upon the daughter Coparcenary. In this case, father of daughter died in 2001, yet the Supreme Court permitted the daughter to claim the right in ancestral property in view of the amendment of 2005. But in this case, the division bench of the Supreme Court primarily did not deal with the issue of death of the father in 2001. Therefore, in such circumstances, the judgment in the Prakash versus Puloti, previous judgment, still held as a precedent on the issue of death of Coparcenary. Therefore, in this present case of Vinita Sharma versus Rakesh Sharma, the larger bench of the Supreme Court held that they did not agree with that part of the judgment in the Dhanamma case which approved the decision in Prakash versus Puloti case, because the Supreme Court in the Dhanamma case held that the proposition regarding living daughter of living Coparcenary was not dealt with specifically. Therefore, in this present case of Vinita Sharma, the larger bench of the Supreme Court has partly overruled that part of the judgment in the Dhanamma case which is contrary to the decision in the present case. In this case of Vinita Sharma, the Supreme Court also dealt with the decision given in one another case of Mangamal versus T.B. Raju, which is reported in the Supreme Court Cases 2018, volume 15, page 662. In this case of Mangamal, the Supreme Court has referred its previous decision, which is given in Prakash versus Puloti and Dhanamma cases. In that Mangamal case, the Supreme Court held that the decision in Prakash versus Puloti case still held the value of precedent for right of a daughter in ancestral property, and thus it was held that only living daughter of a living Coparcenary as on 9 September 2005 will be entitled to claim a share in the Coparcenary property. Therefore, in this present case of Vinita Sharma, the larger bench of the Supreme Court has overruled its previous judgment in both the cases of Prakash versus Puloti and Mangamal versus T.B. Raju. Therefore, on this background, it was observed by the Supreme Court in present case that when a daughter who is claiming and demanding a share in the Coparcenary is alive on the 9th September 2005, then there is no difficulty of interpretation irrespective of the fact whether a Coparcenary has died before the commencement of the Amendment Act. The Coparcenary and the daughter don't need to be alive as on the date of the amendment. If it is to be interpreted that the co-partner and daughter both should be alive, then it will defeat the very purpose and objective of the amended provision. Earlier, the provisions of Hindu law treated a son as a co-partner by birth. Now, daughters are given the same right since birth. However, in case the partition has been effected by metes and bounds and it's adequately proved, then the daughter of co-partner cannot seek partition of already divided property.